Welcome to everyone participating in today's webinar, which is presented by the Washington State Long-Term Care Ombudsman Program, an independent statewide organization that advocates for the residents of nursing homes, adult family homes, and assisted living facilities. The program's mission is to support the quality of life and dignity of all residents by promoting their access to the resident rights that they are guaranteed under federal and state law. Our trained staff and volunteers provide residents, their families, and long-term care professionals with information about resident rights and available resources. They also investigate and resolve complaints concerning resident autonomy and care and help to ensure that residents are treated in a fair and dignified manner. This presentation is one of a series that looks at surrogate or substitute decision makers. And by surrogate decision making, we simply mean that an individual has been given the authority to make certain decisions on another person's behalf and for that person's benefit. You are likely familiar with some common forms of surrogate decision makers, such as guardianships and powers of attorney. Although these types of substitute decision makers are common, the extent and limitations of their authority is not always clear or completely understood by persons working in long-term care facilities. And that lack of understanding may also extend to the residents and those who serve as their surrogate decision makers. The failure to fully understand the limits of a surrogate decision maker's authority can lead to situations that both unnecessarily complicate a facility's ability to care for a resident and negatively impact the resident's autonomy and quality of life. This presentation is focused on powers of attorney and is intended to provide you with information to support your ability to work effectively with residents and their appointed representatives. Today's presentation is divided into 4 sections. Key Concepts presents topics that are essential to developing an understanding of powers of attorney. The next section covers the process for creating and terminating a power of attorney, as well as the importance of knowing when one is in effect. Resident Representative Authority will outline basic information concerning resident representatives, their appointment, what they can and cannot be authorized to do. And finally, we will consider the basic role for long-term care facility staff who are providing care for a resident who has a power of attorney and an appointed resident representative. Before we begin, please also note there is a companion written reference guide that can be downloaded from our program's website, which contains more detailed information than we can cover today. Additionally, the reference guide contains information about how to access the laws and regulations governing powers of attorney, as well as the regulations governing long-term care facilities and the resident rights law. One final point about the presentation: the law governing powers of attorney uses a number of standardized terms. 2 such terms are principal and agent. And principal is the term used to describe the person who creates the power of attorney and gives decision-making authority to a chosen individual to act on his or her behalf. And that chosen individual is described as the agent. Sometimes an older term, attorney in fact, is used. And as this presentation is intended for long-term care facility staff, for practical purposes, the principal is always a resident in a long-term care facility, and so during the presentation I will always refer to the principal as the resident. Likewise, the agent is always the resident's representative, and so during the presentation I will always refer to the agent as the resident representative or simply the representative.